Hello, I'm Joshua Kaufman, an attorney. And in this segment, we're going to talk about works made for hire. This is a concept that is not intuitive for most people. Basically, most people would think that if you have an idea, you hire somebody, you pay them, you tell them what to do, that you would own the copyright in that work product. In fact, you don't. I can't tell you how many times I've heard, "What do you mean I don't own it? I paid for it. It was my idea." It doesn't matter. Under the copyright law, the creative party, by default, will own their copyrights. Now, there are going to be a number of exceptions. The first one, the principal one, is that an employee working within the scope of his or her employment, then the copyright is owned by the employer, not the employee. In fact, for copyright purposes, the actual human who is doing the work doesn't exist. If you fill out a copyright registration and you talk about who the author is, the actual person in the work for hire situation doesn't even appear on the application. It's the employer's name. It's XYZ Design Company. They are considered the author of the work. So we're talking about there again, it's an employee in the scope of his or her employment. Now, there have been a lot of cases talking about who's an employee. What do you have to be an employee? A case went up to the Supreme Court in 1989 to determine that. It was called CC&V versus Reed. And the court there said we look to this set of criteria for under the restatement of agency to decide who's an employee. But for our purposes, let's assume we know what an employee is. Somebody who's working there is getting their benefits, and they're at somebody's office and they're getting a W-2. It's not that simple, but let's just think of it for the moment as an employee, as we all think. So what is the scope of their employment? Well, it doesn't necessarily mean sitting at the office from 9 to 5. If you're working on the weekends or at home on some work-related product or project, it very well may be considered in the scope of your employment, even though you didn't do it on a work time or on a work computer or on a work assets. So the expression in the scope of employment can be broader than just, well, I wasn't at my desk, I was working at it at home. And the flip side of that is, even though you should be working at your own work at the office, but you're working on another project at the office that's not related to your job, and then the boss finds out and they say, well, we own it because you were doing it on our time, on our computer. That's actually not necessarily the case. So if you're in accounting and you're supposed to be crunching numbers and instead you're writing the great American novel at your desk, even though you're using the boss's time and their computer, that's not in the scope of your employment, so they wouldn't own the copyright in your book. You might get fired, but they're not going to own the copyright in your book. But you may be doing some accounting work, designing an accounting program at home on the weekend, which is similar to what you do at the office, and they actually may in fact own that. So an employee in the scope of their employment, sometimes it's easy, and sometimes it's a little rough around the edges to figure that out. Then you have another set of work for hire. That's when you have an independent contractor. And that's where really, in this day and age, the fun comes in, where people think, again, like I said, what do you mean I don't own it? It was my idea, I paid for it. For an independent contractor to have a work for hire agreement, there must be a writing. You cannot have a handshake, an understanding, custom of trade. And even if you had the writing for, let's say, I'm a magazine editor and I've hired the same writer, and 10 times in a row we have a work for hire agreement where it's been signed and it's valid, then on the 11th time I call him or her up and I say, listen, I need an article, please send me something by tomorrow's deadline or whatever it is, and I say fine. He says it's a work for hire and I say fine, and even though we had 10 of those in the drawer, it's not, because on that one there's not a writing. So there has to be a writing for every one of the projects that you undertake. Generally, the writing should be beforehand. There are a few exceptions where you might be able to memorialize it, but best practices would be to get it done ahead of time. But it's not for any commissioned work with an independent contractor. The copyright law limits work for hire agreements to 9 specific items. They would be a contribution to a collective work. They would be part of a motion picture or audiovisual work, a translation, a supplementary work, an instructional test, an answer to a test, an instructional text, an atlas. Those are the 9 things. If it's not on that list, it's not a work for hire. You might have noticed that visual arts aren't there, computer programs aren't there, sound recordings aren't there. They cannot be works made for hire. It doesn't matter what the paperwork says. Now, you're often going to find in contracts language that says, in its own way, to the effect of that this shall be deemed a work for hire. But in the event that it's not considered a work for hire, then in that event, this shall operate as an assignment. So the way somebody protects themselves is if it's not a work for hire, it's an assignment, which is in copyrightees a sales agreement. So you end up selling them the copyright, which in most cases will be synonymous and be the same, but there are rights that a work for hire owner of a copyright has that an assignment does not convey. You can terminate a work for hire, an assignment where you can't terminate a work for hire later on and other things. So again, a work for hire is an employee in the scope of his employment or with a written agreement on an independent contractor of one of those 9 items. If you don't have that, you don't own it, and we'll be hearing you saying, "What do you mean I don't own it? It was my idea and I paid for it," and unfortunately you'll be out of luck. Thank you very much.